All right. Thank you all for being here. My name is Jeff Bachman. I teach human rights courses here at American University. I wanted to just very quickly thank World Beyond War, of course, for choosing American University at which to have the conference. I also want to thank Brienne and Karen Ives, who are both students here, for all the work that they've done to bring this together. Thank you. And of course, thank you all for being here. As you can see in the program, this panel is focused on international law and accountability or lack thereof. We have two very wonderful guests, one of which is also a student here at American University. I will begin by introducing Maja Groff. Maja is an international lawyer based in The Hague, assisting in the negotiation and servicing of multilateral treaties. She works on existing and potential international treaties in areas of child law, issues disproportionately affecting women, disability rights, access to legal information, and other topics. She conducts liaison work with professional bodies and other international organizations and has played a key role in the coordination of international conferences and experts groups. Admitted to the New York Bar, she serves on the United Nations Committee of the New York City Bar Association and is a member of the advisory boards of B Corp Europe and EBBF. So let's welcome Maja, and I'll turn it over to you.
Just there, okay. Lovely. Thank you so much, Jeff. And it's lovely to be here from The Hague and to feel such a lot of energy and dynamism here in the U.S. I work with, I'm Canadian myself, but I work with a lot of very talented American lawyers in The Hague, but not enough interchange with civil society. So this is wonderful. So today I thought I would speak about the underlying vision of the UN system as a legal system and the evolution of international legal institutions, which aren't often enough spoken about, and there isn't enough public awareness of these institutions. So as Jeff mentioned, I'm a practicing lawyer in The Hague in international law, and I've been in and around Hague legal institutions for about 10 years now. And the views I'm expressing today are my own personal views. I'm not representing any organization. And building the international legal system is, in fact, about increasing accountability across a whole range of issues related to peace. So, yes, if we're going to speak about a world beyond war, it's absolutely crucial to address the objectives and mission of the current international legal order and the history of the international legal order, as the aspiration for peace is baked into the very DNA of the international legal project. And practicing in The Hague, I note that international law, the practice of international law is becoming more and more specialized. It's becoming professionalized to some extent, which is positive. However, many international lawyers, international policymakers are losing sight of the overall system, the overall international legal system, which is meant to prevent war. It was meant to ensure sustainable peace at the global level. Also, we have narratives now about the end of history for some time, or there's an acquiescence, for example, in relation to many international legal institutions. But in fact, there's a lot of work that is yet to be done. There's a lot of structural issues that have to be tackled at various international legal institutions. And in my view, there's a lot of scope at present still to make progress and to overcome the path dependency of in the post-Cold War era. In fact, it's a very hopeful era with respect to international law, in my view, at the present. And I think civil society and concerned citizens can seize this opportunity. So, a general observation: resources in international law for durable international peace. Good news, there are many resources in international law. That is also the bad news, because sometimes it's difficult to find the correct projects or areas to focus one's efforts on, and should one focus on disarmament treaties, should one focus on the International Criminal Court, etc. So that is part of the challenge, is to juggle this whole system of international law. And much of what's needed now is, yes, institution building, which isn't necessarily glamorous work, but it's very crucial work to strengthen international legal institutions, and also challenges of coordination between the different areas of international law. So just in a nutshell, what is international law for those of you who aren't familiar? It's classically the law regulating the conduct among states, among nations. Therefore, it's crucial to regulating issues of war and peace and conflict among states. Individuals are to a greater extent now more than ever also subjects of international law, for example, under international human rights treaties. Also, civil society and global civil society is more and more recognized as an actor and a very dynamic player in international legal institutions and in international policy development. Historically, this is a shift because international law generally has been dominated by the executive branches of government. And the sources of international law, of course, are above the national sphere, and you're probably all familiar with the various challenges of implementation of international law at the national level, which are many. I won't go into those at the moment. So why is law essential and integral to global peace? And I'll just quote a beautiful quote from legal and political philosopher Hans Kelsen, an Austrian, some years ago now. He said, "Law is essentially an order for the promotion of peace. Its purpose is to assure the peaceful living together of a group of individuals in such a way that they settle their inevitable conflicts in a peaceful manner. That is, without the use of force, in conformity with an order valid for all. This order is the law." So this notion of international peace through law is a dominant idea in Western political philosophy and ethics. For example, with Hugo Grotius in the Netherlands, where I reside, Immanuel Kant, the famous German ethicist, philosopher, and more modern philosophers like John Rawls. So it's a mainstream Western philosophical concept. Another interesting perspective to consider when we think about international law and a global peace system beyond war are some perspectives, recent perspectives from social anthropologists. This is an excerpt from a very interesting article published in Science by, what's his name? Fry is the anthropologist, and he had studied, I think, 5 different societies, and he tried to identify identified 6 main attributes of these societies which ensured a sustainable peace system. So he noted an overarching social identity, interconnections among subgroups, interdependence, non-warring values, symbolism and ceremonies that reinforce peace, superordinate institutions for conflict management. So the legal institutions are crucial, but they can also contribute to all of the rest of these points. And of course, we can think about in our own societies or at the global level, do we have non-warring values? Do we have symbols of peace which are persuasive to capture the imaginations of global citizens? And these are interesting to consider if civil society groups are thinking of building a global movement. So the notion of progress in international law. From the very outset, origins of the modern international legal order, the advocates for peace through law were very clear that it was a work in progress. It was a long-term project. So, for example, in 1899 in The Hague, there was a first Hague Peace Conference, which I'll mention more about in a moment. And that was anticipated to be a first conference of many conferences to establish peace. In the UN Charter, it was envisioned that international law would be developed in a progressive manner, which in fact it has to a great extent. And you see it in the various provisions of different treaties, that international law is a work in progress, and one of the challenges is to keep pushing forward so that the law keeps developing to realize the vision, the shared vision of many of the professionals of the past and the present. So The Hague as a site of the development of international law, it is very much a crucial key site of international legal institutions and development of the international rule of law. And these are just a few of the tribunals and institutions in The Hague. The ones in bold I'll mention briefly today. But the International Criminal Court probably makes the news the most often, but there are other very important legal institutions in The Hague. So as I mentioned, the Hague tradition started in 1899 when the Russian Tsar Nicholas convened an interstate peace conference. And as you can see in bold, he noted that the object was seeking the most objective means of ensuring to all peoples the benefits of a real and lasting peace, and above all, of limiting the progressive development of existing armaments. So this is still a very relevant modern goal today that we're still struggling with. And in fact, these first two Hague Peace Conferences in 1899 and 1907 didn't have the effects of limiting the armaments of the European powers in particular, as we know with the subsequent two world wars. What did happen at those first Hague Peace Conferences was a treaty to establish the Permanent Court of Arbitration in The Hague to arbitrate peacefully interstate disputes. It furthered the development of international humanitarian law, the laws of war, and a few other treaties that set the groundwork for the development of the League of Nations and then for the United Nations. And at these first two Hague Peace Conferences, civil society was extremely important, sometimes dramatically so when you think of communications at that time. And in terms of an example of the power of one single individual to influence the development of international law, to influence policymakers at the time, there's the Austrian activist, author, peace activist Bertha von Suttner. And there's a quote here from her. It's a wonderful statement on her perspective on civilian peace advocacy. She says, "Only those who have power in their hands, that is something that the pacifists realized, can put the idea into action. For example, nation states."
Baby, won't you come my way? Got something I want to say. Can I keep you on my way? But first off, I'm a start by saying.
Slow down.
I have no idea what that was.
Musical interlude. Wonderful, good news. Okay, but Bertha, also this was her experience at the time. She was a woman, a private individual, excluded from the formal state proceedings. Yet state officials sought her out for her opinion and her policy ideas. And she said, "But the idea, if it is repeated clearly, frequently, and unanimously enough, also possesses a power, namely the power to affect the desire of the mighty to act." And this is very similar to Gandhi's notion of truth grasping, or satyagraha, where there's a universal truth that will have resonance, and the truth of non-violence, for example. Another example from civil society engagement and transnational civil society engagement at this time are letters that women around the world sent to the officials at those peace conferences. This is an excerpt from a women's letter from the Netherlands, from Holland, to their fellow women delegates. And they say, "Dear sisters, fully convinced that in the hands of us women lies the fate of the world in the ages to come, that it is ours to mold it either for weal or for woe, we welcome with joy every effort made to unite and bring together the women all over the world." So women from around the world sent telegrams, letters, messages to the national delegates in The Hague from all over Europe, from Japan, from Russia, from Canada, and the US. And this is one of the messages from the United States, from May Wright Sewall, who notes, "We of the United States regard gradual disarmament," gradual disarmament, the object of which the conference at The Hague is convened as the first step in a perhaps long but straight path which humanity is destined to walk, and which leads undeniably to the goal of universal peace maintained by universal obedience to the decisions of a permanent court of arbitration. Still beautiful, true, and inspiring today, and we're along that path. We're trying to make progress along that path. Now moving on to key bodies of international law and key institutions. Firstly, quite an old body of international law, which was developed to some extent at The Hague, at those peace conferences, also previously in Geneva, and you've probably heard of the later Geneva Conventions also, which are now applied at the International Criminal Tribunal.
It's my house, come on, turn it up. Hear a knock on the door and the night begins.
Okay, I'll just keep going. So the international humanitarian law, which denote the war crimes, basically was meant to civilize armed conflict, civilize the warlike activities of states. So it delegitimizes certain practices and has now been usefully applied at the different criminal tribunals. And there were impulses, for example, at that time in The Hague in 1899 and 1907, to make sure the dictates of the public conscience, the laws of humanity, would apply generally to the conduct of war and the use of weapons. That hasn't been applied legally. There's some legal scholars who argue that it should be, but you see the high ideals and the potential that exists at different times in international law. And international humanitarian law, as an older body of law, does not deal with the legality of going to war. Under international humanitarian law, for example, civilians can be killed legally. That's part of doing war. So this is an older corpus of law that in many ways has been still being applied, but has been superseded by modern human rights law and the UN Charter. So the UN Charter, the vision of the UN Charter. As you may know, the preamble starts very clearly: to save succeeding generations from the scourge of war. It's an inclusive document. It's meant to be universal. Equality of men and women is stated at the outset. The rule of international law is one of the key issues under the Charter. And when you read this document, you get the sense that there's a moment of clarity in the international community and the interdependence of fundamental rights in this order. And it's important to note that the UN Charter is a legal document which supersedes other international treaties, under other international law. So it is a kind of constitutional document at the international level. And the UN has 193 member states, virtually every nation in the world. And importantly, there are the prohibitions, of course, on the use of force that were mentioned earlier this morning. Armed force shall not be used, save in the common interest. There are only two exceptions where the Security Council takes independent action for international peace and security, and then the narrow right for self-defense. So because of this new legal scheme set out in the Charter, legal scholars have argued, for example, Louis Henkin, a U.S. legal scholar, He says that the terminology war was intentionally not used throughout the Charter. It's only used in the preamble as something that the drafters are trying to save the world from. Rather, the language of threats of peace, breach of peace, acts of aggression, etc., are only used. So, in the words of Henkin, international law sought to eliminate the word war, the legal status of war, the institution of war, and the concept of war. And I think that's a very strong legal argument based on the text of the Charter. He notes, Lewis Henkin goes on to note, however, that in national constitutions, this new legal status in relation to war is contradicted. In the U.S. Constitution, for example, there's a War Powers Clause, so that's an older document. So there's national constitutions can be out of step. Obviously, mentalities can be very out of step with this new regime, this new way of thinking. Another utilized part of the UN Charter is Chapter 6 about the peaceful settlement of disputes, which obligates, in fact, all members of the United Nations to settle their international dispute by peaceful means. And it lists a whole range of various ways to peacefully settle disputes, many of which are happening, but still very much not enough, and these peaceful settlement of dispute methods have not been truly embraced, I would say, by the international community yet. So moving to the few Hague legal institutions. So out of the first Hague Peace Conference in 1899, the dream was to create this permanent court of arbitration, which would end war, would settle all disputes among states peacefully. So it was created. How many of you have heard of the Permanent Court of Arbitration? A few of you. Well done. So it was created in 1899. There are currently 121 member states, and caseload is increasing at this institution, which is good. However, many of the cases are commercial disputes between states, private parties. However, there are an increasing number of state-to-state disputes, boundary disputes, which are often the source of conflict, and other issues among states. You might have seen in the news very recently, this summer, there was a decision issued by an arbitral tribunal in The Hague between China and the Philippines on a boundary dispute under the UN Convention on Law of the Sea. So that is a test case in terms of the relevance, the enduring relevance of the Permanent Court of Arbitration. And from some reactions of states to this decision, one can see that international arbitration is still not necessarily accepted, even though it was established in 1899. So moving on to the International Court of Justice, which is a later international legal institution to settle disputes among states established with the UN Charter. So there are many positive aspects of this court. It has a very broad substantive jurisdiction. It hears all matters under international law. All UN members have standing before the court. However, consent is required to take jurisdiction under the court. So the two parties can agree under a particular dispute. There might be a clause in the treaty which refers to the court, or by way of declaration, states may submit to the compulsory jurisdiction of the court. And I just checked the website a few days ago, and 72 states out of 193 who are UN member states have accepted the compulsory jurisdiction of the court. That's less than 40% of UN members. So that in itself is rather shocking and worrying. If this is supposed to be the key judicial organ of the United Nations, how can it be called a true court if it isn't able to keep compulsory jurisdiction? Also, there are other issues in terms of the operation of the court. All of the Security Council members in general have a judge that oversee cases. Judges may be reelected, so you could argue whether that's true independence. And enforcement, there are no truly strong enforcement mechanisms, in particular if the Security Council does not enforce a decision. But again, many positive things of this institution: modern increase in caseload, so states are going more and more frequently to the court. And the court has, in the last 15 or 20 years, really enhanced its jurisprudence in terms of incorporating human rights law and referring to other human rights bodies and jurisprudence. So catching up to modern international law. There are various avenues for reform for the International Court of Justice, which is key to the international legal system. I won't go into them now because I'm running out of time. But just to say, this is something that civil society groups could work on, for example, but it's in general off the radar. International Criminal Court, which most often makes the news and is this extraordinary new achievement as of 2002. I won't go into the dynamics of, I'm told my time's up, so I'll just speed through the ICC, but it is a quite miraculous development that civil society had a huge part to play in its establishment. And again, there are clear weaknesses of the court. For example, key members of the Security Council not being party to the court, such as Russia, China, the United States. However, notwithstanding, 124 states is quite incredible, and there have been quite a number.
I'm just trying to make it clear. Wear Ray-Bans. I'm a great man. Whoa, same friend. I play a whole.
Okay. So, just to finish up, kind of on the where do we go from here topic. So we have a lot of fairly good international law, I would say, but we still have the common values or the investment in this international law which needs to happen. And this is true for the public, the general public, citizens of the countries of the world to understand, but also state officials need to be educated in the basic tenets and the vision of international law. The media needs to be much better educated in international law, etc. There still remain these very high psychological barriers, as war is a tradition, it's a cultural practice, I would say. And this is why the social anthropologists have waded in to try to say, how do we shift to a new peace system? International organizations are sites of, I would say, very fruitful opportunities for reform currently. They're already established and they just need to be strengthened, enhanced. There need to be good ideas injected into their operation. And in terms of the funding investment in these institutions, you're probably all familiar with global spending on the military, 1.7 trillion in 2015. And compare this to spending on Hague legal institutions. The ICJ's budget was 51 million, 2014-2015. The ICC, 130 million in 2015, 153, 2016 proposed. So if you compare, these are very small sums. However, states are concerned about these institutions are very expensive. But if you want to build the conditions for disarmament, for a durable peace, you must invest in these institutions and make sure they stick. Civil society, there have been notable, incredible successes with so-called smart coalitions, citizen diplomacy in terms of international legal reform, the ICC statute, the Landmines Treaty, the UN Convention on the Rights of Persons with Disability, just to name a few. There are people who worked on these campaigns who have shared their views about how to build a successful civil society movement. And in terms of vision for the new international order, maybe I'll just end with, well, two quotations. One from Jürgen Habermas, a modern German philosopher. He's, again, talking about this path and the need to make progress to legally civilize violence between states and societies. This civilizational process we're engaged in. He calls for, or suggests that we need a convincing new narrative from the perspective of a constitutionalization of international law that follows Kant in pointing far beyond the status quo to a future cosmopolitan rule of law. And a last quote from a wonderful UK academic and practicing international lawyer. The true international law is the actualizing in the form of legal regulations of the public interest of true international society, the society of all societies, the society of the whole human race. Thank you.